Does the fact that the petitioner did not file his misgivings on the nominations with the county assembly invalidate his constitutional right to approach this court by way of this petition? In my opinion, the answer is an emphatic no. The Constitution is the supreme law of the land, and in any event, the provisions cited by the respondents in Section 7 of the Public Appointments County Assemblies Approval Act and the Nakuru County Standing Orders allowing the petitioner to lodge his complaints with the County Assembly for an appropriate administrative action are not couched in mandatory terms and cannot in any way override the Constitution. In his petition, the petitioner is raising constitutional and legal issues concerning the process leading to the nomination of the interested parties. The issues relate to discrimination against and or neglect of persons with disabilities and marginalized communities in the said nominations. He is also alleging that some of the nominees were nominated for dockets that they neither applied for nor were they interviewed for. The alleged illegalities and irregularities were allegedly committed by the respondents. It would be improper and illegal for this court to order the petitioner to lodge his constitutional and legal concerns with the same respondents who are alleged to have committed the acts complained of. It would amount to calling upon the respondents to sit in their own case and or on their appeal. That would be against the rules of natural justice, Article 47 of the Constitution, and the various provisions of the Fair Administrative Action Act. Well, this court is aware of the decisions in the Speaker of the National Assembly, versus Honorable James Njenga Karume, and Jeffrey Muthiga Kabiru and others, versus Samuel Munga Henry and others cited above. Among many other decisions cited by counsel for the respondents, this court takes the view that where the issues raised in a petition concern threat, violation or breach of constitutional provisions, and that is the case here, then the Supreme Law takes the lead and the precedent. This court agrees with the decision in Evans Lantema Mswahili versus Kihika County Service Board and two others to the effect that the administrative action envisaged in the above cited statutory provisions are not mandatory and cannot override the right of the petitioner herein to approach this court for adjudication of the legal and constitutional issues raised in this petition. Inasmuch as this court agrees with counsel for the respondents that courts should not unduly and unnecessarily interfere with the operations and functioning of the respondents, in the same token, courts should not sit back in the face of alleged violations of legal and constitutional provisions by any person or body, as adjudication of such breach, violation, or threat is the duty and obligation of this court or of the courts. The doctrine of separation of powers does not operate in a vacuum. This court notes that the County Assembly, which is carrying out the vetting and is supposed to recommend appointment of the interested parties, is not party in these proceedings. However, that may not be fatal to this petition, as this court can still adjudicate on the matters as between the parties before it. Moreover, the parties are free to apply to amend their pleadings at any time along the way, and such applications shall be considered on merits. In the circumstances and for all the reasons foregoing, the POs raised by the respondents are found to have no merits and are hereby dismissed. On the costs, as stated elsewhere in this ruling, this court takes the view that this petition is in the nature of public litigation. Clearly, the petitioner did not file this petition in personam, but in lem, so to say. He filed the petition for common public good rather than for personal gain. For that reason, this court orders that costs be in the cost. So what orders do we make here? This court issues the following orders. A, the preliminary objections by the respondents are found to have no merits and are hereby dismissed accordingly. B, The petition and the other proceedings shall proceed to hearing on merit and on priority basis.